evening. Well, the topic that I'm going to be speaking on is on Section 16 SEPA. I think it's important that, and this is one of the means of, I would say, an application that you will inevitably have to deal with when you're seeking to enforce an adjudication decision. So you have a situation where you start SEPA after the entire period of, say, about 100 days, you then get an adjudication decision, and now you're looking at enforcing it or to execute the decision. And then suddenly, while you're happy with the decision, you're about to go and say, okay, I'm going to go and execute it now because I need to get my money, which I've been deprived of for the last 6 months or 1 year. And then you get a stay application, which basically stops you from executing your adjudication decision until either the setting aside application is heard or even until the stay application is heard. So that's something that we all face when we deal with an adjudication matter. Now, a stay and an adjudication decision can only be done by way of Section 16 SEPA. Section 16 SEPA essentially sets out two circumstances in which you can actually apply for a stay. First is where there is a setting aside application, which is in place. And second is where there is an arbitration, which has been commenced. That's Section 16.1a and 16.1b. At 16.2, on the end says that the High Court may grant a stay of adjudication decision or order the aggregate amount or any part of it to be deposited either with the director of the KLRCA or make any orders as it thinks fit. So that's essentially how Section 16 operates. Now, the question that some of you may ask is, what is then the test in order for me to get a stay? Can I just go to court today, apply for a stay application? Do I get it? How do I get it? And what is the test? What are the things that courts look at? For a very long time, stay application has been predicated on the financial capability or the financial situation of the winning party, the claimant. Until I think view esteem came about. And this was Court of Appeal view esteem, not the federal court. And in view esteem Court of Appeal, the court laid down somewhat what are the parameters that one should look at, although not exhaustive list of parameters. But what are the parameters that one should look at in terms of whether or not to grant a stay? I think some of it is that, I think in that case, one of the things that the court said is that you cannot file a stay and setting aside in a single application, because there was an application filed where setting aside and stay were filed in the same application. The court said you can't do that. But of course, that is pre-Order 69A Rule 4. View esteem was before March 2018. Order 69 Rule A4 came in March 2018, where it sets out the procedure that when you apply for a stay, if there's a pending setting aside, you got to file it in the form of a notice of application. If there's no pending setting aside, you have to file it in OS. And trust me, many lawyers get this wrong, even until today. Because I have dealt with matters where the other side has gotten the entire procedure wrong. And you know, the last thing you want is someone takes a preliminary objections, and the judge might even just dismiss your stay application, not because you don't have a ground for stay, but because you have not followed the procedure that has been set out. Anyway, that's Order 69A Rule 4, which is the current state of matters post 1st March 2018. Now, going back to view esteem, that was sometime in 2017. To that, the court said that the court must be extremely slow in granting an application for stay, because we've got to always keep in mind the objective of SEPA, which is where the contractor's cash flow is very important. And the court also said that unless it is overwhelming that a contractor will not be able to complete his contractual obligation as well as meet up with his financial obligation to the employer, a stay should not be granted. So then that creates a bit of, okay, what is overwhelming and what sort of evidence we need to show. And that created a bit of a, okay, how do I now prove? So what is the real test to get a stay? And then the court also went in to say that just because a contractor is insolvent, it does not necessarily mean that stay must be granted. You know, you got to look at other reasons, other justifiable ground as to whether or not a stay has been granted. So then, just because of that particular paragraph, a lot of lawyers may also be arguing, well, yes, I may appear to be commercially insolvent, but the Court of Appeal has said that that's not necessarily mean that you must grant a stay. And then the Court of Appeal in view esteem said this, and they said it quite clearly, that if eventually a stay is granted, it must, and that's the word used, it must be on the condition that the money is paid to court or a stakeholder account. But if you read that against the wording of Section 6.2, Section 6.2 says that the High Court may grant a stay of adjudication or order the adjudicated amount or part of it to be deposited with the director of the KLRCA. If one were to give it a plain reading, it seems to suggest that the court has the discretion whether or not to grant what is called a unconditional or a conditional stay. But view esteem Court of Appeal, if I remember, I think it's paragraph 32, what the judge said was that even if a stay is granted, it must be on the condition the money is paid to court and or stakeholders' account as the court deemed fit. Now, that is Court of Appeal. Then we came to view esteem Federal Court. I think in view esteem Federal Court, the court basically streamlined the test and said, look, you can, financial circumstances is not the only reason that you can rely on in granting a stay. The court also looks at two other grounds, which is clear and unequivocal error. Some of you may ask me, what is clear and unequivocal error? Until today, people are still figuring out, is the clear unequivocal error the errors which is within the Section 15 limits, or is it beyond? And some of you may tell me, but Dave, if it's an error within the Section 15 limits, isn't that as good as if I can establish it, that means it has to be set aside. So why do I need to get a stay? So where is the line of clear and unequivocal error? The second thing is to meet the justice of the individual case. So when these words are used, it simply means it depends on each facts of the case. So it lies at the end of the day in the hands of your counsel to basically argue as to why in those particular facts of your case, the justice demands that the stay ought to be granted. That was Federal Court. Recently, I think last year, in the Court of Appeal in ASM Development, KL Sinambarat and Ikonpal Sinambarat, in a 2023 decision, what the court said is that there are a few things, but what the court took the trouble to do was to basically set out to actually look at the various case laws, authorities, and put everything in a one paragraph that this is a list of things that one look at when dealing with a stay application. And I will come to that. I will explain to you each of those points. But the court also has also mentioned that just because you have an arbitration that is ongoing, you can't come and tell the court, I have an arbitration is ongoing, I need a stay. That alone cannot be a ground for you to get a stay, because the whole idea of SEPA, going back to the objective of SEPA, is that it needs to help to assist the contractor or the unpaid party with the necessary cash flow. And in deciding a stay application, the court must always consider the intent of SEPA, which is a speedy resolution to the contractors to ensure cash flow. Now, ASM did stick to the same ground that view esteem, which is clear error on the part of the adjudicator and where the justice of the case demands, although they've used the phrase slightly differently. But what the Court of Appeal has taken the trouble to do is to look at all the cases over the years, collate them and say, okay, now I can now, having looked at all these cases, I would summarize that these are the 5 points that one look at, 6 points that one look at when dealing with a stay application. Number one, Court of Appeal said there are only two grounds to support the application of a stay of the adjudication decision. These are two grounds which I mentioned to you earlier. Number two, the two grounds, as explained, must be stringently complied. So you have a very high threshold to make sure that you comply with the two grounds. In respect of the first ground, there must not be just a simple error, but a clear error on the part of the adjudicator in respect of his adjudication decision. The fourth ground is the clear error must be grave to prick the conscience of the court hearing the application to stay the adjudication decision. Fifth, the adjudicator's decision must be upheld even if he has wrongly answered the right question or issues, including on the adequacy or otherwise of the adduction of evidence before him. Six, the court is not to look into or review the merits of the case or decide the facts of the case. So these are the five, I would say, factors or conditions that the court have laid down to assist counsel, parties, as well as judges in dealing with a stay application, to have this at the back of their mind. And the court, somewhere in the case law, I think somewhere at the penultimate paragraph, if I'm not mistaken, had clearly re-emphasized that in seeking for a stay application, and this is the word used by the court, that there is a high burden on the applicant to satisfy the requirements as shown above. And if you do not meet this high threshold, a stay should not be granted. So to summarize the situation is that whilst you can get a stay of execution of the adjudication decision, it is not as easy as just applying it and you getting it. There are tests, clear errors, and I think the Court of Appeal has now clarified a little bit more in terms of what you look at. I think the words used was, it must be grave to prick the conscience of the court hearing the application, and the burden is quite high. So that is where, Kevin, as far as the test of stay of the adjudication decision has developed, pre-view esteem, pre-order 69A, and then from view esteem, we have then come to the latest Court of Appeal decision in ASM development against Econ Pile Capital.
Okay.
Yep.
Thank you, Mr. Dave. I mean, just listening to you, I absolutely seem to understand far better now how to deal with the stay application, and it's almost as if everyone reaches out for a stay application, and any single time an adjudication decision is delivered against one party or the other. It's almost reflex to put in the section 15 and to put in the section 16 and be faced with the section 27 or 28. You mentioned this one thing. I just have this one question, if you don't mind, before I move on to the other speakers. And I want to ask the other speakers to give us their views as well at some point. But you set out here that there are only two grounds to support an application for a stay. The two grounds are stringently complied with. In respect of the first ground, there must not just be a simple error. The error must be clear and must be grave enough to prick the conscience of the court hearing the application. The decision must be upheld. The adjudicator's decision must be upheld, even if it wrongly answered the right questions. And the court is not to look into or review the merits of the case or to decide the facts of the case, is basically what the court had said. I just have two questions. I'm going to put this to you, and then I'll put this to Mr. Deepak and Mr. Satinder as well. To me, at least to my mind, it appears to me two things come out of this. One, when you say that the error itself must be clear enough to prick the conscience of the court, and then the court goes on to say that the adjudicator's decision nevertheless must be upheld, even if he had answered the right question wrongly, and then goes on to say that the court still must not look into the merits of the case or to decide the facts of the case. At least to me, I mean, layperson's and to the contractors and to the employers who are here today and listening to this, it appears to be all very, very difficult and contradictory in a way, which perhaps only lawyers can undo. If you are faced with this situation, and I'm going to suggest this to you, putting these three items of the test together, it appears to me almost as if there's no real test, in the greatest of respect, of course, to the court. It's almost as if it really depends on how well counsel argues the case to raise these issues, that the error is so grave that it pricks the conscience of the court, even notwithstanding that the right person was answered wrongly. How do you deal with all these different aspects of this test that are put together? There's so much that you have to deal with. You can deal with it. Mr. Deepak can deal with it. Mr. Satinder, you can deal with it. But to all the contractors and the users and the stakeholders who are here with us today, how do you simplify this whole thing then? What is it that you would do when you're applying for an application, when you're applying for a Section 16 in court? Practically, what is the pitfall? What are the solutions that you would think of? Just this one question first.
I mean, thanks, Kevin. I think what you've said, you just hit the nail on its head. Because the way the Court of Appeal has now summarized the condition, I mean, to a certain extent, you may say it gets you thinking. So what is the real test? And how do you deal with it? And if you were to look at the wordings, if it says a clear error that pricked the conscience of a mind, are you going to equate that error to the level of what is in Section 15? And if you do that, then my argument will be, well, if it's a level of Section 15, then might as well you set aside the decision.
Exactly.
How can you have a same test for setting aside and a same test for a stay? And if I don't get my setting aside, but I need to prove that level to get a stay, then it's as good as setting aside the decision. So it has to be lower than Section 15. But then it can't be too low, where in the words of the judge, it must be something that pricks the conscience of the court hearing the matter. And how does a particular fact prick or does not prick the conscience of the court hearing, as what you call it, but it depends on how well the counsel argues his case, taking into the facts in hand. That's why personally, I feel that the financial element, financial element is something that is still very important, because that's something that you can look at to a certain extent objectively. You look at the figures, you look at your assets, you look at the losses you're making, you look at the other elements of it. And these are things which the court look at it and they can say, okay, look, it seems like there is a risk here of you not being able to repay the adjudicated amount if a stay is not granted. But to go into the realm of a clear error that pricks the conscience of the court hearing the application, I'm not saying it's impossible, but it's going to be quite an uphill task. And I think for the counsel who is trying to resist the stay, he will also or she will also have a lot of points to say, no, this is just an error. It's not an error that pricks the conscience of the court hearing the matter. Those are my immediate thoughts, Kevin.
Okay, so the takeaway from your answer and from your presentation would be this. I'm going to put this to both you and Deepak as well as Satinder. Is this: number one, although the court has tried its best, and I think the court has done very well in trying to encapsulate or to reduce the entire argument into a test here in paragraph 47 of the grounds of judgment. At the end of the day, really, it is a case-by-case basis. There is no real one size that fits all. It really comes down to how you argue a case and to suggest that perhaps it falls within items D, E, and F of the judgment. And I absolutely agree with you, Mr. Dave, that ultimately it all comes down to dollars and cents. And the financial position of the party in whose favor the adjudication decision was given is extremely important, because once the money is paid, there's always a question as to whether or not you're going to get back your money if the arbitration goes the other way. Mr. Deepak, what are your thoughts?
Yeah, so now I think one of the points that Dave raised interesting is the test on clear and error. right? Clear and unequivocal error by
Yes.
view esteem, right? There's a bit of confusion as to what does this mean, right? Now, if you look at the recent cases, and I'm talking about ASM decided by the Court of Appeal decision by Justice Abu Bakar Jais, the Court of
Yeah.
Appeal.
Yes.
And if the way I read his lordship's decision is, his lordship, when he summarized the principles, before he did that, he referred to Justice Lim Chong Fong's decision in EA Technique, where Justice Lim Chong Fong said that when you talk about clear and unequivocal errors as far as view esteem is concerned, they are only talking about errors in the context of Section 15 and not in the context of errors in the adjudication decision. And then if you read paragraph 47 of his grounds of judgment, he goes on to say you cannot review the merits of the case.
Yeah.
And then if you read the federal court decision in Ikon Pa, Justice Hasna has also said that the only way you can oppose an enforcement if it offends the principle of natural justice or excess of jurisdiction. All of this seems to suggest that this clear and unequivocal error is limited to the grounds in Section 15.
Mm.
That's what I get from the cases. Right. Now, in terms of practicality for a contractor, why is this Section 16 important for them?
Mm.
I think this is a question that the losing party will want to know. If you have lost the SIPA decision, what you want to know is how do I preserve myself? Because look, somebody with a SIPA decision can go now with a winding up, can go with a direct payment. So what you need to do is to apply for a Section 16. The Section 16(1)(a) is where I would file an application in court and do my best to get an ad interim stay pending the determination of the Section 16 application. And if you get that, you can avoid the hassle of a winding up, avoid the hassle of direct payment until your setting aside application is there. This is on the assumption that you have a basis in your setting aside. Right.
Thank you. I just want to ask you this one question, because it's following from what Dave had mentioned earlier on, to be careful with the use of rather applying for a Section 16, given the changes to Order 69 of the rules. And you mentioned just now going in for an interim stay. How would you do this? If you can just explain to all the participants here.
So I think nowadays when you file an application for stay, almost invariably the courts will normally fix the matter to be heard together. Right. You're setting aside application and your enforcement. Okay. So normally what you would do is you would put in a prayer to ask for an interim stay pending the determination of the setting aside. Where
would you do that? You'll put in the application for interim stay in the which application?
In your application for stay.
Okay.
Right?
Okay.
Right. So it depends. If you file a setting aside application, you've got OS, whether you put it inside there. So you have to look at the Order 69. But what you would do is, practically what you need to do is you need to apply to court and ask for the matter to be called and heard on the interim stay. Because your goal is to get the interim stay application heard, get the interim stay pending the hearing date. So this is to prevent the contractor from going and availing itself from winding up or direct payment.
Parallel to whatever is happening,
yes, parallel to whatever.
They start attacking elsewhere and well, utilizing and using up resources unnecessarily. Yes. While the central question as to whether or not the adjudication decision should be upheld or not should really be the item that should be disposed of by the parties first, which is exactly what the three of you were discussing just yesterday. And I want to emphasize this, which is why I asked you this, because a lot of young lawyers who are present here today, a lot of young lawyers, a lot of pupils, and it is very important for all of the younger lawyers and pupils here to understand these sort of strategies that are employed by these senior lawyers here, Mr. Dave, Deepak, and Satinder, and they do and what they do and how they go about making sure that they are not attacked from a different end. While a lot of the focus should really be on the Section 15 as well as the enforcement applications as well. So this is what these gentlemen do. So please, I hope you're taking notes and also to take note of Order 69. Satinder, your views on paragraph 47 of the Court of Appeals decision in Ikon Pa and the test. Do you have anything else to add, sir?
Actually, I'm actually very much with both the learned speakers here, especially with Deepak. Practically, that's something we have to do these days with all the uncertainties coming up with the winding up based on adjudication decisions. So practically, definitely Section 16 and go for an ad interim until you get your hearings on the setting aside as well as the enforcement dealt with. And also, I think you should really arm it up with whatever you can, what Dave has put forth. I think that's something that we have to look into. The financial aspects, come in with audited accounts, come in with all the SSM reports, come in with as much information as you can to build up your case on why a stay should be granted, chances of not recovering back the judgment sum if payment is made out, and of course, as far as you can, look into the clear errors that you can identify.
Thank you to the young lawyers and the non-lawyers here. Please take heed of what Mrs. Satinder just said. Don't just go into court with guns blazing. Go into court prepared. Make sure all the documents. Don't just make averments. Don't just say what you need to say. Go in there with all the backing and all your accounts and all your financial statements. So you want, depending on whoever it is that you are representing, you know what to say based on the documents that you have. And until today, I'm sure all three of the speakers here will agree with me. Until today, we have situations where parties go to court, they make averments, but they don't have the underlying documents to support and fortify what the lawyers are saying. Or what
Can I just add one thing as well, Kevin?
Yes, Dave.
This is regarding where we're talking about stay, and this is something that I think is very real since we're talking about real life experiences. See, to get a stay, you must either have a setting aside application at hand, already filed, or an arbitration. Now, to get a setting aside application, you need to review the adjudication decision, assess the position, and then come up with the grounds. Similarly, for arbitrations, sometimes there are contractual clauses which sets preconditions to commencement of arbitration, and usually it's at 30 days, for example. So you can't commence your arbitration, say, for example, within the next 30 days. But you have to file your stay. And to add it all, the adjudicator only gave you 1 week to pay the money, the adjudicated amount. So in 1 week, on the struck of the midnight, they're going to go for winding up. They will go for all sort of execution. But you have 1 week to get your setting aside in order, your stay, or if necessary, arbitration. And in between, there may be other things, I'm not sure, there may be some public holidays or otherwise. So this is a real situation that the counsels who are handling the case must be prepared to deal with.
Thank you. These are real issues to all the participants here. These are real potential attacks that you might face. These are tools that you might need. Take your notes, and be prepared based on all these pitfalls that all three speakers have raised. Now, I'd like to move on to the next speaker and to the next topic. Deepak, on Section 30, and let's call it the attack on the principle in a construction contract framework. Deepak?
Okay. Thanks, Kevin. Okay, can you all see my screen? Can you see my screen, Kevin?
All good.
Okay. Okay, so I'm going to be dealing with Section 30. Now, just now, Dave spoke about stay. So that is to stop the enforcement of an adjudication decision. Now, when we talk about adjudication decision, they have essentially, SIPA provides for three main ways of enforcing the decision. You can go by normal enforcement, filing an enforcement application in court. You can go for suspension. And the third approach is winding up. Of course, the fourth one is, the third approach is direct payment. And the fourth one is winding up, which Satinder will talk about later. So my area is going to be about direct payment application. So let's start with what are the requirements under Section 30. Now, I'm not going to go in so much detail into the basics of Section 30, but I think what the important case is Cabinet Systems M. Sendirian Berhad against Deckard Caliber. This is the case where Justice Wong Keng Keong had laid down the 4 conditions that must be satisfied by the winning party in the SIPA decision if he wants to apply for direct payment from the principal, right? So if you see at the bottom left side, there is a box there where I put X, Y, and Z. That's how Justice Wong has described the parties. X meaning the person who has succeeded, Y is the losing party, and Z is the principal. Y is a contract party essentially, right? So Justice Wong has summarized that under Section 30, you first have to establish that Y, the losing party, has failed to pay the adjudication amount, right? So if it's usually you get a SIPA decision, and if you are required to pay within 7 days, if after 7 days the payment has not been made, you've satisfied the first condition. Second is after that, the winning party can then make a written request to the principal for the adjudicated amount to be paid directly to the winning party. This is the second condition. The third condition is must be a sum of money due from the principal to the losing party at the time of your direct payment notice. So remember, the time period is when you serve the notice of the direct payment notice. At the day you serve the direct payment notice, there must be money due and payable from the principal to the losing party. And of course, finally, the principal fails to comply with the direct payment request and it does not pay the amount. That's the fourth condition, right? So these are essentially the 4 conditions that you need to satisfy in order to succeed in a direct payment application. And these requirements were very recently followed by the Court of Appeal in JDI BillTech. So Court of Appeal says, look, they cited with approval this case by Justice Wong and say that these are the requirements under Section 30. Now the topic today is dealing with common pitfalls. So when I look at Section 30, what I see is 4 common pitfalls. One happens is when the losing party and your person that you obtain a decision becomes wound up. The second is where the identity of the principal is not clear. The third is what extent you can recover the adjudicated amount. Is it just the principal sum? Can you recover interest? Can you recover costs? And finally, the burden of proving whether there's money due and owing by the principal to the losing party. So let's start with the first one. So of course, the big problem here is winding up. If the losing party is wound up after you got your adjudication decision, there's a big problem for you. And I think the case that has resolved this issue is City Indah Construction. This is a Court of Appeal decision. Now, what actually happened in this case is City Indah was the subcontractor. They had a contract, they pursued a SIPA claim against a main contractor, which is known as BHL Builders. They got a SIPA decision for about 9 million plus. The main contractor failed to make payment. And as a result, City Indah proceeded with a direct payment application, the notice followed by the application. And I understand that after that, BHL Builders, the main contractor, the losing party, was wound up. So the issue before the High Court was, because when a company is wound up, assets under the Companies Act, there's this thing called undue preference. You cannot prefer one creditor over the other. And so the question was whether Section 30 was subject to this undue preference provision in the Companies Act. And this is what the High Court said. The High Court said, number one, there's no independent obligation and liability imposed on the principal to make direct payment. And the principal's payment to the subcon would amount to a preferential treatment, view of the fact that BHL Builders was in liquidation. So this matter was taken up to the Court of Appeal. And I've put here the Court of Appeal reversed the High Court's decision. And the Court of Appeal said that, look, Section 30 creates an independent statutory obligation on the principal in its own right to pay the contractor, which existed in parallel with BHL Builders' obligation to pay the subcontractor under the adjudication decision. And the Court of Appeal also went on to highlight that the principal's payment to the subcon would not be from BHL Builders' assets, but because the adjudicated sum was paid by the principal, it would then later be a debt due from BHL Builders to the principal, in which the principal would then have to recover from BHL Builders pursuant to Section 30. So this is how the Court of Appeal has interpreted and basically have placed Section 30 to be more powerful than your undue preference provisions in the Companies Act. right? So this common issue now, because of City Inda, I understand that the leave application was not allowed. So because of City Inda, this issue is now resolved as far as if the main contractor or the losing party is wound up. The next issue, the common pitfall is if your identity of your principal is not clear. Now that happens sometimes. So section 4, if you see at the bottom of the slide, section 4 defines what is the principal. It says a party who has contracted with and is liable to make payment to another party where the other party has done. It's a very long statement, but in simple terms, what it means is it is the person above, the contract party above the losing party in the adjudication decision. That's what it means, right? Who is the direct contract party of the losing person in the adjudication decision? Now, it is quite, I mean, sometimes you have a scenario where your client, because your client is the person, if your client succeeds in a CIPA decision, or if you are a claimant and you succeed in a CIPA decision, not all the times the subcon will know who the main con is contracted with. Most of the time they will know, but not all the time you will know, because of a complex contractual arrangement that the companies sometimes they, establish subsidiary companies and so on and so forth. So one such example was a very recent case of Progress Center Engineering against Desaru, the Desaru Group. In this case, Desaru appointed MRCB as the main contractor. And then MRCB, who is agent, which is another subsidiary company of MRCB Builders, appointed the subcontractor. The subcontractor then, of course, there was non-payment. Subcontractor pursued a CIPA claim against MRCB Builders, obtained a CIPA decision. They obtained a CIPA decision. Of course, the next step they do is to demand for payment. And MRCB writes back, MRCB Builders writes back to the subcon and say, look, I have been acting as an agent for MRCB all along, and actually we haven't gotten payment from Desaru. So now, of course, the subcon is faced with the issue as who should be the principal in this case. Is it going to be MRCB or should it be Desaru, right? So what did they do? In this case, what the subcontractor had done, they had issued 2 direct payment notice, one to Desaru and the other to MRCB, because they were not sure who the identity, who was the principal. They issued 2 direct payment notice. MRCB, of course, replied back and said, look, I'm not the principal, because MRCB Builders was my agent. So as far as I'm concerned, Desaru is the principal for the purpose of Section 13. And when it went to the High Court, so when they filed the application in the High Court, Section 30, they filed it against both Desaru and MRCB, and they sought the prayers to, for the High Court to determine who the principal was, right? High Court took the position that agreed with MRCB that MRCB and MRCB Builders were principal-agent relationship, which was recognized by Desaru at all times during the construction period. And by its conduct, MRCB has treated MRCB and MRCB Builders as one and the same, and as a result, both of them are placed in the same level and can be considered as main contractor. And as far as Section 4 is concerned, Desaru would be construed as the principal under Section 13. So in this case, High Court found that the principal here was Desaru. All right. So it largely depends on the facts of the case. But in this case, I thought when the identity of the principal was unclear, the claimant here was quite clever to try his luck and file action against both parties. Let the court decide. I don't want to get involved, right? So that's one way of trying to resolve this confusion, right? Leave it to the courts. The next is this other issue is the extent of what you can recover under Section 13. Now, nobody thought this would be an issue, but I'm sure if you read CIPA, if you read the entire legislation, when Section 30 refers to the word adjudicated amount under Section 30, there is no definition of an adjudicated amount in the entire act, right? So lawyers being lawyers, whenever opposing a Section 30 application, they will raise arguments that, look, adjudicated amount, as far as I'm concerned, when the principal is concerned, should only be limited to the principal sum, should not be interest and cost. Because the logic most of them argue is, look, my contract is only for the principal sum. I've got nothing to do with cost and interest. I shouldn't be made liable to pay that. So for a longest time, there was confusion as to what is an adjudicated amount as far as Section 30 is concerned. To what extent can the principal be liable under Section 30. And the confusion was quite bad because at one point you had one High Court decision saying that adjudicated amount is only the principal sum that you get in your SIPA decision. Excludes interest, exclude cost. And that was in the High Court decision in this case by Justice Alizan. Then you had Justice Wong Keng Keong, as his lordship then was in the High Court, who took the position that an adjudicated amount is only the principal sum and the interest, but excludes cost. Then you have another interpretation by another High Court judge to say that adjudicated amount includes all three. So you got three different interpretations at one point in time. So I had the privilege of acting for Bond M&E in this case in the Court of Appeal decision, and we took it up as a point for the Court of Appeal to decide. In this case, the High Court actually allowed the direct payment application, but the problem was the High Court didn't allow interest and cost. And in this case, the interest alone was so big, was going up to almost 800,000. It's a huge amount. So it was worth it to take it up on appeal. And we took it up on appeal, and the Court of Appeal reversed part of the decision because the High Court allowed the Section 30, only didn't allow interest and cost. And the Court of Appeal said that, look, adjudicated amount would include both interest and cost, in addition to the principal sum. The rationale, apart from going through the intent and object of the Act and coming to the conclusion that the interpretation closest to the intent and objective of SIPA is you must include interest and cost. The Court of Appeal also said that, look, it also doesn't make sense if you're the winning party and that you would have to file recovery twice, once against the principal, and then go after the winning part, go after the losing party for interest and cost. That surely is not what SIPA intended. So that issue now is put to rest. The Court of Appeal made it very clear: adjudicated amount includes interest and cost. So that pitfall, that issue now is put to rest now. Next issue is the final pitfall that you will see is the burden of proof. Now, if you are a principal, most of the time the question arises, or if you're the applicant in Section 30, the question that you're asking yourself when you file a Section 30 application is, how do I show whether there's money due or payable between the principal and the main con or the losing party? I'm not involved. I'm not part of their contract. How would I know whether the money is due or payable? So when we didn't have case laws, that confusion was there. We didn't know. The applicant, it was difficult to show how do you show there's money due and payable at the time of the direct payment notice. So in this case, in JDR BicTok, the Court of Appeal decision, the subcontractor here secured an adjudication decision against the main con, and thereafter issued a direct payment notice followed by a direct payment application. The principal took the position that at the time the notice was given to him, there's no money due and payable. And the evidence they showed was that, look, the contract with the main contractor was terminated before the direct payment notice. There was a total of 41 million plus due and owing, comprising of many claims. And there was contemporaneous QS report prepared to justify this amount. The subcontractor basically took a very hardball approach, said, look, you cannot set off all your so-called claims that you have, you cannot set off against your contract with the main contractor. And the subcon said that, look, you must pay me directly. The High Court disagreed, dismissed the application for direct payment because the subcon had failed to discharge the overall burden of proving there's money due or payable. Now, another thing you all need to know about this case, under Section 30, there's something called Section 30 sub 2. That means after you serve your direct payment notice, when the principal receives the direct payment notice, Section 30 sub 2 makes it mandatory for the principal to issue a notice to the losing party, right, of the SIPA decision, to ask him, look, I give you 10 working days to let me know whether you have paid the winning party. If you don't get back to me within 10 working days, I will proceed to make payment. He's supposed to issue that notice under Section 30 sub 2. Now, you would realize that many High Court cases have taken the position that if the principal fails to issue a notice under Section 30 sub 2, it is fatal to his defense that there's no money due or payable. So some applicants under Section 30 have taken the position that the moment you don't put in a Section 30 sub 2, I can claim. whatever you want to say, there's money due, no money due or payable doesn't matter, because the courts have said it's fatal, right? So this position, how do you reconcile Section 30 sub 2 and Section 30 sub 5, where 30 sub 5 says there must be money due or payable at the time of the direct payment notice? So this was clarified by the Court of Appeal. The Court of Appeal said that, number one, if you fail to serve a Section 30 sub 2, it cannot automatically mean that you must pay the amount sought by the winning party. And the cases that have held that must be read in proper context. The Court of Appeal said that Section 30 sub 2 must be read subject to Section 30 sub 5. That means you must first satisfy that there is a money due and payable to the main contractor at the time of receipt, and only then direct payment can be effected. So essentially what it means is, it matters not that the principal didn't serve a direct payment notice. If he can show that at the time he received the direct payment notice, there was no money due or payable, he is under no obligation to pay. That's what the Court of Appeal clarified, right? So that's as far as Section 30 sub 2 is concerned. Now let's come to the legal and evidential burden. Now this position on the burden was, the Court of Appeal followed Justice Wong Keng Keong's decision in LTK Fasad. Now Justice Wong Keng Keong very nicely summarized the position by saying that in Section 30, all the applicant of a Section 30 has to do, you must satisfy the first, second, and fourth condition. So that means the first condition is you basically must have obtained a SIPA decision. Obtain a SIPA decision which the losing party has failed to make payment. Second condition is the direct payment notice must have been issued. And the fourth condition is the principal fails to pay after the direct payment notice. So then Justice Wong said that the moment you satisfy the first, second, and fourth condition, the evidential burden shifts to the principal to show there is no money due or payment, right? So the Court of Appeal said that is basically followed that position. But what the Court of Appeal added is, they added this thing to say that what the principal must do, as far as the evidential burden is, they must show that it can be, they must show by adducing credible evidence of a bona fide dispute with the main contractor, and documents to show, to substantiate there's no money payable at the time of receipt of the direct payment notice. So this clarification is good because it explains the extent that the principal must show evidence that when he received the direct payment notice, there was actually no payment due, and therefore he's under no obligation. To what extent can the burden be discharged? And in this case, the Court of Appeal said that the evidential burden was discharged by the principal because there was a joint inspection after the termination of the main contract. And the QS had prepared a report on 12th of January 2021, which was much before the direct payment notice was issued, detailing the main cons defaults and the estimated additional cost of 26 million. The LAD costs, the principal was able to adduce evidence of all the LAD costs incurred. And based on the total QS computation and the principal's assessment of LAD and so on, it was total of 41 million at the time the direct payment notice was issued. So on that basis, the Court of Appeal said that, look, this evidence appears to be credible evidence to show that you've discharged that your burden, that there's no money due at the time of the direct payment notice. The Court of Appeal also said that in this contract, there's this PAM 25.4D that states that upon determination, the principal is entitled to withhold payments. And the Court of Appeal said that the principal could rely on this provision to deny payment, right? And therefore, overall, the Court of Appeal said that, look, as a result, the legal burden, the subfund had failed to establish under Section 30 sub 5, and the appeal was dismissed. So that essentially was the case in the Court of Appeal. But I want to, for our discussion after this, highlight certain remarks that were made by the Court of Appeal as far as the decision is concerned. The Court of Appeal said that Section 30 would be most suitable in cases of continuing performance of the works, where there has not been any termination of the main contract and where performance of the works under the main contract and within the various subcontracts are ongoing. So what I seem to understand from this, the Court of Appeal is saying Section 30 is most suitable if the contract is still ongoing. It doesn't apply for the issue. It's not suitable if it's terminated or the contract is complete. That's what I seem to understand. But I take this as an obiter because this was not part of the main ratio, right? And then the Court of Appeal's decision on 25.4D of PAM contract. The Court of Appeal agreed with the slew of cases. I think all of you would know there are these numerous cases that have taken the position that clause 25.4D of PAM conditions is void because it comes within section 35 sub 1 because it defeats the purpose of SIPA. The Court will agree that this should be with this line of cases, one of which was also Justice Lee Swee Singh's decision. They agree that this should be a conditional payment provision, but they clarified it is only confined to adjudication proceedings. If there's no adjudication proceedings, parties, the 25.4D can still be relied upon, right? And lastly, Justice Lee says these remarks, and I've highlighted the relevant part. His Lordship has said that SIPA does not transfer the risk to the principal, and neither was it designed to improve the position of the subcontractor to the detriment of the principal. All SIPA does in line with its prophylactic properties is to help parties pursue payments due without causing prejudice to anyone affected by the process. It's very reasonable, but I have my reservations, which I will discuss later. So essentially, that's all I have for my presentation. Thank you. I just want to quickly acknowledge my colleague Lou Nanny, who has helped me prepare this slide. So if you like the color and everything, it's all thanks to her, right? Thank you, everyone.
Deepak, thank you so much. Let me just jump straight into the questions that I have. I don't have many, but if we can just ask you to do this, Deepak, and which will also be helpful for everyone. Your slides, the third last slide that you had put up, if you don't mind, can you just put that up again? Okay, and because you said right at the end that you have reservations. So I want to try to peg the question, or rather the question of you having reservations to the third last. Yes, that's the one, correct.
Right.
Yes. Now,
Okay.
these are some of the comments that were raised by Court of Appeal, correct?
Yes.
Now, just to summarize what you had said, there are two things that we have to think about. Number one, Cabinet, which sets out the 4 conditions, which is quite clear. And two, now here in this case, which echoes the decision by Justice Wong Kin Keong, of course, which basically says that if you meet conditions 1, 2, and 4, then the burden of condition number 3 then is for the employer to show that really there are these genuine circumstances, or rather evidence to show that there are in fact, or there is in fact no monies due and owing by the employer to, I'm using employee loosely, of course, I mean principal, but as an example, I'm just going to say employer, due and owing to the main contractor. And of course, in JDI BuildTech, the employer very skillfully managed to explain away that they did not in fact owe anything to the main contractor. You said you have reservations. Now, in the context of these 3 items here that you had set out here, number one, that SIPA Section 30 is really more suitable in continuing performance of the works, and 2, the applicability of clause 25.4, agreeing with the slew of cases as well as clarifying that it's really confined to adjudication proceedings. What are these your reservations, or do you have any further reservations?
Yes, of course. The next slide of transferring the risk. It's a fair statement to make. I'm saying it's a very fair statement, but we need to read a bit more into it. So those are my 3 remarks that I put there, that I had some reservations with the Court of Appeal decision. But Kevin, I must say, on the facts of the case, I agree with the Court of Appeal, because basically the principal had discharged his burden, and it's fair that Section 30 shouldn't be allowed in that case. On the facts, I think it was a fair decision.
But which means, Deepak, if you go back one slide, if you don't mind. Here, okay, this is what the principal did, didn't he? Correct?
Yes.
And evidently, the principal was able to show that there was a joint inspection, that there were, in fact, all this money is due for LED, that ultimately there's a QSS computation assessment of 41 million and so on and so forth. This is very fact specific, isn't it?
Yes.
So there's no real test, isn't it? It's really a question of whether or not the employer, or rather the principal, can show that the principal, he or she, does not in fact owe any money to the main contractor, correct?
Right. Yes.
At the end of the day, again, there's no one size that fits all. It is the kind of evidence that the principal, more often than not the employer, can bring to court to say, I really do not owe the main contractor, main contract X amount of money. It's not just a question of basically what you had said. It's not just a question of saying, I do not owe the main contractor X amount of money for the work for which you are now claiming and secured an adjudication decision. In this case, if the employer or the principal can show that as a whole, I do not owe the main contractor any money at all, then this case can bite. Is that what this case means?
Yes, yes. That's what I understand it to be. As long as you can show at the time of the notice, you don't owe any money, right? Because of you have a valid dispute to the debt, which is in this case the LAD, the calculation by the QS of the additional works that will be the cost of the additional works to complete the remaining works. If you can show that, right? Because what the Court of Appeal said is you have to bear in mind that the disputes between the principal and the main contract will go through a final determination, whether through the court or whether through arbitration. So the court, when assessing a Section 30 application, is not in a position to determine it on a final conclusive basis. That's why the test is a bona fide dispute, that you can show or satisfy the court that, look, you have a genuine dispute and this is your dispute, then the evidential burden can be discharged.
Allow me to just tweak the facts just a little bit, okay? And I'm putting this question to all three of you. Fact specific. Let's just say, for example, the adjudication decision is for non-payment of payment certificate number 36, okay, hypothetically, and that is specifically for one item of work in the project, okay? And let's say, for example, the adjudication decision was obtained, and for that particular item of work, even the employer has not made payment to the main contractor for that particular item of work, even though a progress claim has been submitted by the main contractor. All right, let's assume that those are the facts. Does that also therefore mean, given JDI BillTech, that if the main contractor, if the principal or the employer comes to court and says, I can, and even admits, look, I've not paid even the main contractor for that particular item of work, but because of all these other items, say LAD and a computation by the QS or some other assessment and all the other things put together, it overshadows, it wipes out the amount of money that has to be paid to the main contractor. Wouldn't that then put the subcontractor who has an adjudication decision in his or her favor at a disadvantage? Because they've managed to prove that I've not been paid for this particular item of work. I have to go after the main contractor now, but only because the employer or the principal has all these other things in his toolbox to say that ultimately there's a greater amount of money that is due and owing by the main contractor to the employer, it may end up defeating the very purpose of Section 30. Of course, I'm putting this. I'm putting this example is purely hypothetical, and I'm putting it at the very far end. But if that situation were to arise, wouldn't that be unfair to the subcontractor?
Yes. So Kevin, I think what the court was trying to do was trying to balance the rights between the principal and the subcontractor.
Right.
And I think what we need to bear in mind, while the subcontractor has a right to go for direct payment, the caveat under Section 30 is there must be money due or payable. So what I understand from the Court of Appeal's decision is, that means the caveat that Section 30 says is at the time of the direct payment notice, there must be money due or payable. And the way I understand the Court of Appeal is that so long as the principal, because the principal under their main contract, the employer and the main contractor, they will have certain clauses that allows for set-off, whether it's LAD or whatever. If it's terminated, then you've got certain provisions and you can claim. And some of them may actually have a genuine claim. So it is a scenario where if the principal can show that under its contractual regime or contractual agreement with the main contractor, it has a valid basis to claim these amounts, right? The court is going to say that, look, okay, fine. Then on that basis, you can satisfy your burden. But you're right, that can open itself to a different sort of abuse. So Kevin, what I realize now, it is very common practically, and that actually happened in the case of Pali PTP and bond. When a SIPA proceeding is going on between the subcon and the main con, almost invariably the main con has pursued a SIPA against the employer. So what I normally do is I find out whether there's a SIPA decision between both the parties,
Right.
principal and main con. And
Mm.
if there's a SIPA decision and the amount that the payment has not been made, I get on that and make that my main basis to say it's payment due and payable. And it
Okay.
was that basis that I succeeded in filing against PTP, because then that whole argument of LED and all this issue doesn't make sense, because the court took the position someone has already decided it and concluded that there is an amount payable which you should pay.
Exactly. Excellent strategy and solution. And for all of those who are here today, especially all the younger lawyers and the pupils and the non-lawyers, take this particular strategy away from what Deepak had just explained. Because when you are faced with these sort of situations, you really have to be very nimble in how you move forward, because all sorts of manners of things and strategies can be thrown at you. This is certainly one thing that you should think about if you're faced with such a situation, especially if you're the main contractor sitting in between the subcontractor and the employer. Okay, I'll just ask Dave, Satinder, do you have anything else to add on this issue before we move on to Satinder?
No, I'm okay. Nothing further to add.
Thank you. Dave?
No, I've got nothing further to add, but I do agree with Deepak. I think we've got to draw a balance here. One is it's in respect of the rights of the subcontractor who have not been paid against the main contractor. And the other one is also the right of the principal who has his own set-offs and LEDs, etc., against the main contractor. So I guess that's where the balance has to be drawn in terms of pursuing the objective of SIPA as well as protecting the contractual rights of the principal under its contract with the main contractor.
Absolutely, absolutely correct. I don't think, sorry, Deepak?
Kevin, before you move on, I think that very quickly I wanted to say,
yep,
the reservation I had in section 30, because this position that the Court of Appeal said that it doesn't apply, it most suited for cases in which the works are ongoing. I don't think it's an accurate reflection. And if you look at all the cases, in fact, all my cases that went for section 30 were cases where the works have already finished. Because it always is the case that during the currency of the project, parties will try to avail themselves of the contractual, like spam, you have direct payment mechanism, and they will do that. So section 30 is not commonly used when the contract is ongoing. That's one. And two, I wanted to bring to the participants' attention, 25.4D, this is a very controversial provision. And why I say that it's contradictory by the Court of Appeal to make this statement, because on the one hand, they say, look, for SIPA decisions, if you get a SIPA decision and the respondent raises 25.4D, you can say it's a conditional payment because it defeats the object of SIPA. But on the other hand, the Court of Appeal says, but if it's raised by the principal, it's not a 35.1 because there's no adjudication. But why different treatment? Because isn't that also a possibility that the principal will raise it to defeat the intent of SIPA? And that to me, it's a dangerous thing to say, because I think this can be open to abuse, and that's my reservation.
So take this away from the speakers today, all over here. Keep your eye on these comments on section 30, as well as clause 20. Sorry, that was 25, right? 25, yeah, 0.1 of the PAM contract. All right.
5.4D. Yeah.
Sorry, 0.4D. Sorry, correct. That actually arose. It was first raised by, I forget the name of the case, Justice Deepak Singh, isn't it? In 2018, it was a High Court decision. The name of the case. It went to the Court of Appeal, which agreed with Justice Lee, but there were no written grounds in the Court of Appeal, isn't it? I just forgot the name of the case. I'm having a bit of a senior moment here. I'm so sorry. But allow me then now to move on finally to our final speaker. Everyone, please hold on. We need to hear from Mr. Sandhu what exactly was held in the very recent case, the Court of Appeal case in Blue Dream, which we are all hoping has finally brought an end, if at all, to this very old, long, never-ending argument as to whether or not one can rely on an adjudication decision to petition to wind up the party against whom the adjudication decision was made. Satinder?
Yep, sure. Thank you, Kevin. Okay, I'll just share screen now. Okay, just a bit of history before we get on with the whole Blue Dream case. There were several decisions before that has taken different approaches along the way with regards to whether you can wind up based on an adjudication decision. The first one, of course, was the MRCB High Court decision by Justice Darrell Gun, where at that point in time, it was a case involving a Fortuna injunction by the plaintiff to restrain a winding up petition presented by the defendant. Now, in this case itself, the court dismissed the plaintiff's application for Fortuna injunction and found that the adjudication decision is to be regarded as if it were a judgment of the High Court for the purposes of enforcement. If not honored, the resultant debt is a judgment debt, and that was one of the other factors in the decision not to grant the Fortuna injunction was because two applications for prior applications for stay of execution had been refused. Then the next case in the development of this area of law was the ASM development and Econpile case 2021, also with regards to the Fortuna injunction, not the main case. Again, another decision by Justice Darrell Gun, where in this case, the defendant sought a Fortuna injunction to restrain the plaintiff from filing a winding up petition against the defendant, which was eventually allowed. Key takeaways from this one was the court found that in the opposite way, basically the adjudication decision is nonetheless enforceable as if it was a decision of the High Court. It is a basis of a statutory notice. And the court also said if the debt or adjudication decision is genuinely disputed upon substantial grounds, or if there exists a genuine cross-claim, counterclaim, or set-off that amounts the amount that is greater than the debt, then the court may issue a Fortuna injunction. Okay, that was a bit different from the earlier case. Then we came to the two cases, the Court of Appeal decisions in Likas Bay and also the Court of Appeal decision in Sime Darby. In Likas Bay, one of the main issues was whether the winding up notice by the respondent had been premature as there was no enforcement of the decision yet. The Court of Appeal in that case held that adjudication decisions in favor of the respondent petitioner had evinced the fact that the amount as stated in the adjudication decision was due and owing. And in that case, there was no setting aside of the adjudication decision applied as well. So the court found that the adjudication decision was good and proper basis for the winding up petition notice to be filed for a debt in the amount as stated in the adjudication decision against the appellant. Here, the court agreed that for the purposes of filing for a notice to wind up under Section 465 of the Companies Act, the litigant did not have to register the adjudication decision under Section 28. So basically, after Likas Bay, you didn't have to go and enforce the decision. You can just use the adjudication decision and proceed to file your statutory demand notice. Then we went to the next case in Sime Darby, another Court of Appeal decision. In this case, the issues were whether there was a disputed debt as the respondent had admitted the debt owing in the written payment response, and whether the grant of the Fortuna injunction was an abuse of process of court, and whether the respondent had no financial capability to pay the debt. The Court of Appeal made this statement in paragraph 50, where the court said that in our minds, this does not equate to entitling the party ordered to make payment under the adjudication decision to an order to restrain the successful party from presenting a winding up petition, as the former has statutory right to challenge the statutory notice or petition before the winding up court. Until and unless the adjudication decision is set aside, it can in law form the basis for the statutory notice, which has the position in the present instance. Whether or not the respondent had a bona fide cross-claim against the appellant on merits to challenge the petition is a matter to be adjudged by the winding up court. And they said, we are not convinced that an unproven cross-claim can be the basis for restraining the winding up of a winding up petition based on a valid and enforceable adjudication decision. So here the court actually found that the High Court had erroneously granted the Fortuna injunction and dismissed it with cause. So those were the cases. Now we come to the recent decision in Blue Dream, which was recently decided in March 2024. It's a Court of Appeal decision, and here the brief facts were basically there was an adjudication decision. Adjudication proceeding, commenced an adjudication decision obtained in favor of the respondent for about 5.5 million plus interest and costs. The appellant applied to set aside and stay, and the respondent applied to enforce the proceedings. After the enforcement of the decision, a few days later, the appellant's architect issued a valuation report number 37, interim certificate number 7, and revised statement of final account. Before that, the respondent had applied to enforce the adjudication decision by filing a winding up application for 6.1 million. Now, in the High Court, at that point in time, the winding up petition was filed by the respondent in the Shah Alam High Court. The appellant applied to strike out the petition, and this was dismissed. Subsequently, the appellant applied for a Fortuna injunction to restrain the winding up, but this was dismissed as well. The winding up petition was then allowed by the court, and this is what then Justice Dato' K.K. Wong stated. He said the debt which is premised on a decision pursuant to SIPA, pursuant to an enforcement order, is a judgment debt. To reiterate, the Shah Alam High Court had allowed the petitioner's application to enforce the adjudication decision, and the respondent's application to set aside and stay the adjudication decision had been dismissed by the High Court. Furthermore, the Court of Appeal had unanimously dismissed the respondent's appeal and had upheld the decision of the Shah Alam High Court. Thus, the respondent's argument that the adjudication decision is of temporary finality and the filing of the winding up petition, which is solely done to prevent the respondent from pursuing the counterclaim in its ongoing arbitration, is devoid of merits. Additionally, in respect of the appellant's arguments that there was no sums due and owing because of the reports filed by the architects, the London High Court judge found that these were issued after the adjudication decision had been delivered in favor of the respondent and were disputed in the arbitration. So, and also these arguments had been raised earlier in the enforcement, setting aside and stay proceedings. So the judgment debt, according to the London High Court judge, was an undisputable debt. And on the solvency issue, the London High Court judge found that the appellant had failed to adduce credible evidence to show it was commercially solvent, financially fit, and capable of paying the debt. So in the High Court, the parties put up various arguments. The appellant actually strongly argued that the party who had successfully obtained an enforcement adjudication decision cannot proceed to rely on the adjudication decision to commence a winding up when the adjudicated dispute had been referred for final determination to arbitration. Basically, they're trying to say that there's been a final determination going on in arbitration and court. So this adjudication decision cannot be used at that point in time to wind up the losing party. According to them, according to the appellant, this is premised upon there being no express provision provided in SIPA, as well as depriving the appellant of its right to be heard in the arbitration. Since the status of an adjudication decision is that of a temporary finality only, the right to wind up a company based on the decision is contrary to the legislative intent of SIPA. Otherwise, the company would be wound up based on an adjudication decision that has permanency from which the company cannot recover. They also argued that the arbitration proceeding had been commenced against the respondent by the appellant, and its cross-claim based on the revised final valuation of the completed works, remediation of defect, and liquidated damages for late completion. These cross-claims, according to the appellant, would extinguish the adjudication claim. So they're saying for these reasons, the winding up should not be allowed based on the adjudication decision. For the respondents, they argued that there was already case law, and the case law It's already there that appellant may be wound up based on the SIPA adjudication decision. And they also said that based on the circumstances, the facts and circumstances of the case, the appellant had failed to pay an undisputable debt that was determined in the decision and should be correctly wound up and was correctly wound up by the High Court. Now, this is what the Court of Appeal said. Court of Appeal says the law is settled. The crux of it is that the unpaid successful party who obtained the adjudication decision may opt to wind up a non-paying party. Secondly, a company may be wound up on the grounds of inability to pay debt, albeit the payment sought is not a judgment debt. Okay, it can be wound up even though it's not a judgment debt. Here, the court said, for an unpaid debt unadjudicated in a SIPA proceeding will be disputable only if the non-paying party has prima facie established a bona fide dispute of the debt on substantial or reasonable grounds. If the dispute on the debt has been adjudicated, with adjudication decision obtained in favor of the unpaid party, the debt ceases to be disputable in the ensuing winding up proceedings. This is because the disputed debt has been independently adjudicated by a neutral third party. More pertinently, it should not be open to the non-paying party to again dispute the debt when the sanctity of the adjudication decision has been preserved by the subsequent court orders refusing to set aside and or stay, as well as allowing the enforcement of the adjudication decision pursuant to Section 27, 16, and 28 of SIPA. Consequently, it is immaterial in the winding up court that the non-paying party still disputes the adjudication debt and has referred the dispute to arbitration. So that was the finding of the Court of Appeal here. The Court of Appeal did acknowledge, though, that they are mindful that these proceedings are draconian in nature and which may result in irreparable damage to the business, but still paid heed to SIPA's legislative objective, i.e. to facilitate regular timely payment, provide a mechanism for speedy dispute resolution, and provide remedies for recovery of payment. They also talked about the class, how the respondent will be a class of creditors. They said, we know that the respondent will be possibly amongst many unsecured creditors, will claim on the appellant's asset, and there is no assurance that the adjudicated debt will be wholly recovered from the wound-up appellant. That aside, there is also often a significant lapse of time between the appellant entering into liquidation and making payment to the creditors by liquidation. This is a commercial choice of the respondent, probably the last resort because other enforcement remedies had been pursued without fruition. On the other hand, we have also duly considered and find that if the appellant is wound up, the appellant through the liquidator may still recover from the respondent should the appellant ultimately succeed instead of the ongoing arbitration proceedings between them. The Court of Appeal also distinguished expressly the ASM development case and Satya Fontaine's versus Protec Enterprise Sdn Bhd in the judgment. The Court of Appeal then confirmed the Learned High Court judge's finding on the unilateral issuance of the revised final account and certificates by the architect, as well as the lack of solvency of the appellant. And the appeal was ultimately dismissed with cause. So the key takeaways from this one, from this case, is an unpaid successful party who has obtained an adjudication decision may wind up the non-paying party, notwithstanding the adjudication decision has not been enforced under Section 28 of SIPA. An unpaid debt unadjudicated in a SIPA proceeding will be disputable if the non-paying party has prima facie established a bona fide dispute of the debt on substantial or reasonable grounds. If the dispute on the debt has been adjudicated, which resulted in adjudication decision obtained in favor of the unpaid party, the debt ceases to be disputable in the ensuing winding up proceedings. And it's not open to the non-paying party to again dispute this debt in the winding up proceedings, especially if it's already been decided in the setting aside, stay, or enforcement proceedings. And finally, it is immaterial in the winding up court that the non-party still disputes the adjudicated debt and has referred the dispute to arbitration for determination. That's all, Kevin.
Satinder, thank you very much. That was a really, really comprehensive explanation historically where it all began, all the way to what the arguments were, the competing arguments, and finally what the Court of Appeal held in Blue, not just held, but said in Blue Dream. I'm going to ask the three of you this one question. I'm going to ask in this order and sequence, Satinder first, Dave second, and Deepak last. Has this dispute, this question, this never-ending argument of whether or not a party can rely on adjudication decision to wind up the other party, has this issue come to an end? Satinder?
To me, it appears to be so, but well, I know for a fact that they are still, the appellant is still appealing to the federal court, and there's a leave application pending.
To the federal court, rightfully so, rightfully so. But at least in your view, given the narrative in this set of grounds, you feel that at least for now, this issue has come to an end, correct?
Yes, sir. Yeah.
Thank you. Dave?
Sorry, I was muted. Well, I think so too. I think it does set a certain ending as far as this thing is concerned. But as I say, argument can always be raised, particularly on the issue of how do you dispute the bona fide dispute of that. On one hand, you say, I think if I looked at Satinder's takeaway, I think the second last slide, what Satinder was saying is that you can't dispute the debt that had already been decided in the adjudication. Then the question then lies is, what sort of bona fide disputes can you then raise, which is not an attack against the claims that is being sought in that adjudication decision?
Exactly.
And that opens up the whole thing all over again.
Yes, right.
So if I can't dispute the debt which I am seeking for a winding up, then what other debt am I disputing which makes it a relevant consideration for a Fortuna? I will leave this for everyone to think.
Deepak, has this come to an end?
I agree, it has come to an end, and my take of it from that decision is essentially now Section 16 has become very important. That, you know, the moment you get a CIPA decision, if you want to avoid a winding up, go for your stay, get your stay. That seems to be the only way you can stop a winding up.
Yeah, but Deepak, if you were to say that, then you're diluting what you said earlier on, because if the argument has come to an end, then there's no need to rush for a stay. So it means, while all of us would like to say that the discussion, at least for now, has come to an end, we're not really that sure, are we? Because there's still so much of room for one party, and all these young lawyers who are here today, all of you, at some point in time, you're going to be facing Mr. Dave, Mr. Deepak, and Mr. Satinder, and either the Kuching High Court or the KL High Court or in the Court of Appeal. And these are the sort of arguments that you're going to be raising, isn't it? I mean, look at paragraph 31 of Blue Dream, where the court has said, although the principles of winding up of a company for inability to pay debts are right, the ultimate decision whether to wind up the company is fact-centric, which opens it up again. Because if the court is going to say it's fact-centric, then does it really bring this to an end? I'm not suggesting that either three of you are wrong, because I too feel that really this argument should have come to an end already, especially with Blue Dream. But you'll always find all these clever lawyers who are paid enough money in terms of fees, who will raise this sort of arguments, isn't it? To utilize paragraph 31 of the Act. And the conflation of the question of temporary finality with the principles of winding up under Section 456, or is it 465 of the Companies Act, which are two different sets of principles. But the attempt to put them all together to come up with a decision, I still think there's a lot of room still for all these clever lawyers here to raise a lot of issues. And hopefully, since you've already expressed and explained that this thing is going up to the federal court, let's see. Let's all stay tuned to see what the federal court finally has to say. There's a question on the question of temporary finality. There's a question of even if there's an adjudication decision that can be relied on or used to wind up one party or the other, do you still go back to the Fortuna principles? You know, the old Mobicom 2005 Court of Appeal principles. If there's a bona fide debt, sorry, if there's a bona fide challenge to suggest that there is in fact not a debt, is the party then still entitled to the Fortuna injunction? All these things, I think will become live again in the federal court. But for now, I agree with all three speakers. For now, at least, I hope all of this comes to a stop and comes to an end. For now, you'll all notice that even the Sime-Darby decision, Sime-Darby and RSH, the Court of Appeal decision, although reported in 2002 on MLJ, I think the decision was out in August or September of 2021. And right after that, right after August or September of 2021, when the Court of Appeal decision was out, you have this whole host of High Court decisions saying no. They went back to the old ASM and Nikon High Court decision, and they said, no, sorry. I'm going to give you this, the Fortuna, you cannot use a High Court, what do you call it, an adjudication decision to move a petition to wind up a company. So let's hope now with two Court of Appeal decisions, Sime-Darby and RSH, and now in Blue Dream, this thing settles, everyone calms down, and well, hopefully there will be greater light that might be shed in Blue Dream in the federal court. But for now, I noticed I've got no further questions. I also have checked, I can see from the chat screen, there are no questions that have been put up by any party. Is there anyone else who would like to ask a question? I'm not sure if you can put on your mics, but if there's anyone, I just count down to 5, 4, 3, 2, 1. So there have not been any questions. We've come to 7 o'clock. The flyer did say 5:30 to 7. If there are no further questions and I have none left, I think this was simply an excellent, my take, excellent session. 3 amazing speakers, so much information, but just on 3 very focused questions and areas, which I hope all of you here have had a lot to take away from in terms of argument, in terms of strategy, in terms of the pitfalls that you have to look at, in terms of solutions and how to get around some of these pitfalls, which I hope you can one day raise against all 3 of the speakers, in some other cases that you might be up against all these 3 gentlemen. But for now, I have nothing further to add. Thank you very, very much, Mr. Darshendev, Mr. Deepak, Mr. Satinder, for a supremely insightful session today. I would return the mic to Sharifah. Thank you. Thank you.
Thank you to our speakers and to the incredible moderating skills of Mr. Kevin Prakash.
Yes, I agree.
He has given compliments to everyone else, and now we reciprocate and compliment his moderating skills as well. One of the best that we have so far. Yes. I'd like to highlight that for everyone here who is still with us until the end, thank you so much for staying with us. We hope that you participate in our future big talks, and that this is part of our efforts to celebrate the 10th year anniversary of SIPA. For our next big talk, we will have Federal Counsel from AGC. We will have the State Attorney General, Deputy State Attorney General from Sabah. We will also have a litigator who is well-versed in public sector projects. So please stay tuned and sign up for our next big talk. And thank you again.
Thank you. Thank you, everyone.
Thank you.